Well, good afternoon. Thank you so much for joining us for the National Sea Grant Law Center's webinar series. I'm Stephanie Otts. I'm the director of the National Sea Grant Law Center, and I'll be joined here today with the rest of our team to do a federal regulatory roundup for all of the activities that seem to happen right there at the end of the Trump administration. I encourage everyone just to double check, make sure that you're stayed muted to eliminate background noise, but you can ask questions in the chat box at any time. The rest of the staff attorneys are kind of watching the chat box and will answer questions as they can. And we will also have time for questions at the end. So we are also recording the webinar. We will post it on our website later today as soon as we're able to get it up. So please share with your colleagues and others that might not have been able to make it today. So just an overview of what we're going to do today. We're going to talk briefly, just a little backgrounder about the federal regulatory process. And then we're going to give status updates on what we're calling the midnight regulations. And so these are regulations that were published by the Trump administration after the election, but prior to the inauguration. And so we'll talk a little bit about kind of why that time period matters. And then we'll do some really rapid fire, quick takes on other agency actions to watch. So just a reminder for those of you who might be new, we're one of the 34 Sea Grant programs. We're based at the University of Mississippi School of Law. We're here to serve you, the Sea Grant Network, and all of the Sea Grant programs, and we provide non-advocacy, legal research, outreach, and education services to the network. Don't forget to follow us on Twitter and Facebook. That's the absolute best way to know what's going on with the Law Center is to follow us on social media. But I also encourage you to go and explore our website. We archive all of our information and work that we've done on our website. And you can find the recordings of these webinars under the news section, which is where we put our webinars. I also just wanted to remind everyone that we do have an advisory service. It's a legal research service provided free of charge to Sea Grant programs. This is research only. We are prohibited from providing legal advice, but we do strive to answer whatever question your programs and staff might have. This is especially important. As you'll see from this webinar, there is a lot going on right now. There's a lot of different rabbit holes that myself and the other attorneys can go down, and it's really helpful for us to hear from the network about what questions you have, what is coming across your radar screen, what you need more information about. So please feel free to reach out to us either individually to any of the attorneys or myself as a central clearinghouse. Okay, so we'll just dig right in. So just a bit of a background. So the federal regulatory process is constrained or kind of outlined by the Administrative Procedures Act. So the Administrative Procedure Act applies to all agencies within the federal government. This is the piece of legislation that prescribes procedures for agency rulemaking. So there's requirements to publish proposed rules and provide public comment and review, and then publish a final rule. And there's constraints on what can change between the proposed rule and the final rule based on the type of comments that have been received. It also sets forth standards for judicial review of agency action. So all of this is basis of what we'll be talking about next with all of what's happening with these regulations, right? So a lot of it is just what is set forth by the Administrative Procedure Act. All of these notices are published in the Federal Register. If you're not familiar with the Federal Register, but you do encounter federal regulations in your work, I'd really encourage you to visit federalregister.gov. This is the journal of the federal government. Basically, it's where all of the notices that the agencies publish are made available to the public. You can also get 2 dockets for individual rulemakings where there's more information. And any of us would be happy to give you a bit of a primer on the Federal Register if it's something that you think would be worthwhile. So here's just a chart that has been put together by George Washington University that shows the number of rules published by presidential year. And I think it's really informative to show that what is happening right now between the transition of the Trump administration to the Biden administration is not unique. It's been going on since at least the late 90s. You can see 92, a spike, 2000, 2008, again in 2020, where there is a bit of a rush of the outgoing administration to finalize regulations before the inauguration, right? Before they get kicked out of the White House, they want to try to get some things in place that they had been working on or kind of rush out the door. There's also an incentive or effort by the incoming administration to stop what was happening there at the end, right? So these political transitions can have a significant influence on the way that policies mean different things. On how it works. So there was a question about economically significant. So I think they were looking at rules that related to like the regulation of industry, like the Clean Air Act, power plant type regulations, the ones related to cars, kind of regulated industries, separating out. There's a lot of rulemaking that's just procedural or kind of around the edges that isn't as impactful for the regulated community. So I think that's the distinction they're trying to make there. So as we go through this, just want to point out that, it's not, unique what's happening now. It's just a little more high profile because of the political tension surrounding the transition and how much of a whiplash in some sense it is with respect to environmental policy from the Trump administration to the Biden administration around some of these issues. And so with that, we just wanted to, before we go through the various regulations that we're looking at, wanted to give a bit of an overview of the Congressional Review Act. So Zach, I'll turn it over to you.
Great, thank you, Stephanie. As we go through the rules during the rest of this webinar, this is a mechanism that you're going to want to keep in mind. It may not end up being applied to all of them, but it is a mechanism that is at Congress's disposal right now as it considers how to act or which rules it's going to act on in the coming weeks and months. As Stephanie mentioned earlier, and it definitely goes with this topic, you could do a deep dive. You could do a full webinar, I think, just on the Congressional Review Act, but this is going to be a bird's eye view, what it is and why you might be hearing a little more about it in the coming weeks if you haven't already. So I mentioned it's a congressional mechanism, and it's specifically a mechanism that Congress can use to overturn recently finalized rules that have recently been finalized by federal agencies. This is a deceptively simple description. We're going to break it down. So first, how does it overturn them? Well, the Congressional Review Act provides the procedures. It indicates that any member of either house can bring a joint resolution forward, and then if that joint resolution gets the approval of a simple majority of both chambers, it gets sent to the president. The president can veto it, in which case Congress can overturn that veto. But once that joint resolution is enacted, it not only overturns the rule that it identifies, but it prevents the agency that issued that rule from issuing it again or issuing a rule that is substantially the same. There is a lot of controversy about what this means. One of the more interesting and controversial elements about the Congressional Review Act is that it's very, very difficult to get judicial review, so there isn't a lot of material to work with here. But the big takeaway is that if a rule is targeted successfully, the rule is negated, and the agency that promulgated that rule cannot issue it or a substantially similar rule moving forward. I also mentioned that these are recent rules. Now here, recent means 60 days, and that's not 60 calendar days. It's not even 60 business days, 60 legislative days, 60 days that Congress is in session, which means that that window ends up stretching for a deceptively long period of time. Now it's going to stretch all the way back to rules issued on or after August 21st, 2020. As recently as November, scholars, commentators thought it was going to go back to May. And then all of the negotiations over COVID stimulus changed that a little bit. Even so, that 60-day window stretches back to August 21st, which means that all of the rules that you're hearing about today, as well as any rules issued all the way back to that date, can be overturned by Congress through that procedure identified earlier involving a joint resolution. This means that 1,400 rules are potentially eligible to be overturned. However, Congress is realistically likely to prioritize only 10 or 20 of them. How do we know this? Part of it is practicality. Not every rule is going to be all that controversial or politically undermining to the next political administration, the next transit in light of this transition. So it's important here to consider the context. This bill is actually fairly recent, the bill that led to the Congressional Review Act. It was enacted in 1996, and prior to 2017, it was only successfully used once for a rule that would have required ergonomic chairs for federal employees. That was in 2001. And this actually makes a lot of sense if you think about it. It's not very likely to pass when the chambers are controlled by different parties. And then it also requires the president's signature. He's not likely to sign a joint resolution that would overturn something promulgated by agencies that he himself is overseeing. So it really only comes up during these political administrations where not only the White House is turning, but both chambers of Congress are turning with it. This is the same circumstances that arose in 2016 to 2017 with that election and following transition, when the rule was used to overturn 16 Obama-era rules. And this is another one of those rabbit holes, rules actually extends to some guidance as well. So for CRA purposes, it actually means something slightly different than what might be published in the Federal Register. Anything in the Federal Register is generally going to come under this umbrella, but agency guidance, policy interpretation, statements of policy may also come under this purview. It's something that is very expansive, very powerful, and something you're very likely to hear more about in the coming weeks.
Great, thanks, Zach. Yes. And I also should have mentioned before we turned it over to Zach that the Biden administration, as one of their very first actions coming in after the inauguration, issued a memo directing federal agencies to place a 60-day freeze on regulatory action. So what this meant is to try to freeze in time anything that was trying to work its way through the rulemaking process to give the Biden administration a chance to take a look, see what's going on, and how they want to move forward. And we'll come back to kind of some of the guardrails that the administration has put up for what they're going to do during that review period. So there's a whole range of possibilities that we might see in the coming weeks with respect to rules that were issued both in this window during the political transition, but also even prior to that, that the new administration, no longer supports. But we've broken it up into, there are rules that were published as final in the Federal Register before the inauguration. And then there are some rules that were proposed, but hadn't made it through all the way through the regulatory process to become final. With a final rule, so if it was published in the Federal Register as final, there's a whole lot of things that could happen. One, the Biden administration might be fine with the rule and they don't take any action, and then that rule will become effective just like it always would. In the memo to federal agencies issued by the Biden administration, they suggested that agencies should consider extending or delaying the effective date of rules that were kind of finalized here at the very end, or possibly reopening a comment period to, again, gain more time to think about what might happen. So we might see this as well. We might see some new comment periods coming out or delays in effective dates. They could be repealed by the Biden administration through notice and comment rulemaking. This is a lot of work. It takes a lot of time and effort for agencies to go through the rulemaking process. It can take a minimum of a year, sometimes 2 years to get through the process, and that's if nothing happens, right? So that's something that's possible, but will take much longer. We might see a repeal through the Congressional Review Act. It could also be upheld or vacated by a court ruling. As you'll see throughout this webinar, there's a lot of litigation going on right now around these rules. For the proposed rules, the agency has a little more flexibility. They could take no action, which just means they don't issue a final rule, and that proposed rule just fades away, just kind of goes off the books. They could open a new comment period to get some more feedback, and they can issue a final rule with some changes. But it's important to note that both the Administrative Procedure Act and court precedent really places constraints on how different the final rule can be from the proposed rule. So it may be that in some of these proposed rules, the version they might want to move forward with is too different from the proposed rule issued by the Trump administration, that they just have to start over with that. So again, there's going to be a lot of uncertainty, and it's going to take several months, if not more, to really know where we're going with some of these rulemakings. So the first rule that we're going to talk about, which you may have heard about, the shorthand for this has become known as the Science Transparency Rule. This was a rule issued by the EPA. The purported purpose of the rule was to add clarity or transparency to the type of studies that EPA would use when they're making significant regulatory actions or influential science information. The proposed rule initially came out in April of 2018. There was a long delay before the final rule actually was published in January of this year. There were some supplemental notices of rulemaking related to this rule that tweaked the scope a little bit for whether it was going to be more than just dose response data, how the studies were going to be used. In general, this rule was targeting the use of public health studies where the underlying data was not made publicly available because of privacy issues or HIPAA. So maybe it was a public health study that had a small sample size, and that if you release the data, it would infringe on privacy. Historically, the EPA had relied on these type of studies when making decisions under the Clean Air Act, like cost benefit for pollution regulations, those type of decisions. So this rule was going to very narrowly constrain the EPA and say the EPA can only use studies where that dose response data is publicly available and in a format that could allow replication or validation. This rule was extremely controversial, as you can imagine. I took a screenshot of the docket, and you can see it received almost 1 million comments through the rulemaking process. So this is one that was finalized within this window right before the inauguration. So it was published as a final rule January 6th. What was really interesting is that the administration said the effective date was January 6th, the same day. That's very different. Normally, under the Administrative Procedure Act, regulations come in effect 30 days after they are published. And the desire is to have a note, everybody gets notice, right? That this new rule has been published. You've got 30 days to learn about it, and you have notice that it's becoming effective. There are 2 exceptions to this 30-day delay requirement. Procedural rules that just relate to agency internal procedures can become effective immediately. And then agencies can also try to invoke a good cause exception to the rule so that it comes into effect early. The EPA tried both of these. In their final rule, they said this is just a procedural rule. It's just about how the EPA internally decides what studies to use. And also, we think that we have good cause for making it effective immediately. Primarily, they said it was essential to restore confidence in the EPA decision-making process. Well, immediately, environmental groups filed suit against the final rule, so didn't take them very long. On January 11th, this case moved very quickly. The court granted the Environmental Defense Fund motion for summary judgment on January 27th. The court found that this rule was substantive. It really did constrain the EPA's discretion about what it could rely on in making regulatory decisions, and that wasn't just a simple procedural rule. They also did not accept the EPA's good cause argument to make the rule effective immediately. And so the judge ordered the rule to become effective 30 days after publication, which would have been February 5th. What was really interesting, and to keep in mind that this is again part of this political transition, is now the EPA is under a new administration, right? It's under the Biden administration. And so EPA filed a motion requesting that the court vacate the rule and remand it to the EPA. They said, well, since you decided that it was substantive, and actually that mattered because of the statute the EPA used for their authority. They said, we can do this under a federal housekeeping statute. It's procedural. That's what our requirement is. So if it's not procedural, they can't use that statute as the justification. So the Biden administration said, well, we don't have grounds or authority to issue this rule anymore, so you might as well vacate it. And so the court agreed. So earlier this week, on Monday, the court granted the EPA's motion to vacate the rule and remand it to the agency. So this takes it just completely off the books. So this rule is now gone. It's been vacated. It saved the Biden administration a lot of time because this was a rule that people thought would have to go through notice and comment rulemaking to be repealed. So this was a huge win for the Biden administration in court as well.
Okay, so hi everyone, I'm Kathy Janesty. So I'm going to talk briefly about the Migratory Bird Treaty Act rule that just came out on January 7th. And so for those of you who don't know, the Migratory Bird Treaty Act is considered a strict liability statute. So the terms of the statute itself say that it's unlawful at any time, by any means, and in any manner to pursue, hunt, take, capture, or kill migratory birds, or attempt to engage in any of those actions. And so there's no requirement of intent in how the statute is written. And so traditionally, the way that this has been treated is to use prosecutorial discretion, which means don't bring cases against actors who, maybe didn't have intent and it was an accident, you're driving and a bird hit your windshield. But a new regulation that the Trump administration had proposed and now just finalized on January 7th says that those prohibitions only apply to actions directed at migratory birds, their nests, or their eggs. And so the rule is taking the position that the MBTA should only apply to intentional actions. So any incidental take or killing isn't prohibited under the act. And their reasoning for that is to, they have this statement in the actual rule that says they don't want to transform average Americans into criminals because you are subject to criminal liability. And they said that the American people under the Constitution need notice of liability. So that's the position of why they're justifying making this change to how the Migratory Bird Treaty Act is kind of interpreted. So you can go next slide, Steph. So this was, immediately challenged. So the state of New York, along with 11 other states, have filed a lawsuit in the Southern District of New York on January 19th. And so they're just seeking a declaration that this rule is unlawful, and they're asking the court to vacate it. The lawsuit's in very early stages, so we don't really have more than that statement to really go on at this point. It's just in the initial kind of filing and motion stages at this time. So I'll pass it to Tara, I think, now.
Hi, yes, this is Tara Bowling, and I'm going to talk about a couple of rules promulgated under the ESA, the Endangered Species Act. So when the Fish and Wildlife Service or the National Marine Fisheries Service list a species under the ESA, the Act requires the listing agency to designate critical habitat for the species. And critical habitat is defined by the ESA as an area that's essential to the conservation of a species. So while that term critical habitat is defined by the ESA, the term habitat was never defined in the ESA, nor by the Fish and Wildlife Service or NMFS regulations. So this became an issue in a 2018 US Supreme Court case regarding the dusky gopher frogs listing. The Fish and Wildlife Service listed the critical habitat of the species in Mississippi and an area in Louisiana. The species originally lived in areas of Mississippi, Alabama, and Louisiana, but now it's only found in 2 counties in South Mississippi. And so it designated the area in Louisiana, reasoning that even though the species aren't found there now, it is unoccupied critical habitat because it contains ephemeral ponds that are necessary for the species survival. And so the plaintiffs in this case were Louisiana property owners, and they objected to the critical habitat designation. They argued that the land in question didn't have all the elements necessary to be habitat for the species. And the Supreme Court agreed and held that an area designated as critical habitat had to be habitat for the species. And so to address this, the Fish and Wildlife Service and NMFS issued a proposed rule on August 5th, 2020, and then issued the final rule on December 16th, 2020, defining habitat. And the rule specified that this definition is only to be used for the purpose of designating critical habitat. And it just reads, for the purpose of designating critical habitat only, habitat is the abiotic and biotic setting that currently or periodically contains the resources and conditions necessary to support one or more life processes of a species. And this language kind of narrows how the federal agencies applied the term habitat in the past, and it possibly precludes the agencies from designating critical habitat in areas that don't currently meet resource or condition thresholds, even if they could in the future. And so this was effective January 15th. It's already been challenged in court and is under review, which I'll talk about after I move on to the next rule. So this is the mandatory exclusion rule. It was proposed September 8th, 2020. It was final December 18th, and then effective January 19th, 2021. And the Fish and Wildlife Service also issued this rule in response to the US Supreme Court's ruling in the dusky gopher frog case. So as I mentioned earlier, there's a statutory requirement to designate critical habitat in the ESA. However, the ESA says that the designating agency may exclude an area from critical habitat designation after taking other factors into consideration. These might be the economic impact, the impact on national security, or any other relevant impact of including the area in the designation if the agency determines that the benefits of the exclusion outweigh the benefits of inclusion. So typically, courts have held that the decision of whether to exclude an area is a discretionary decision by the agency that's not reviewable under the APA. However, in this case, the Supreme Court said excuse me, these types of agency decisions are, or they should be reviewable. So to address this, the Fish and Wildlife Service issued this rule. They stated that it must consider exclusion when a party presents credible information regarding the existence of a meaningful economic or other relevant impact. And it also states that the Fish and Wildlife Service must give weight to the expert or firsthand information unless there is material evidence that rebuts that information. So the effect of this rule may be that it prevents the agency from using its discretion to decide whether to designate particular areas as critical habitats. And it also gives the opponents of critical habitat designation more weight in the agency's decisions. So on the next slide, I'll just mention that there were already a couple of lawsuits filed. Conservation groups filed 2 separate complaints in a Hawaii federal district court challenging the habitat definition and the mandatory exclusion rule. The groups say the rules violate the ESA, NEPA, the APA. They're asking to vacate the rules and to stop the Fish and Wildlife Service and NIMS from applying or using the rule or the definition. So these 2 rules are under review by the Biden administration. They were specifically identified as ones that would be reviewed, so they could possibly be repealed or revoked or modified in the future.
Okay, so now we're going to talk about the nationwide permits that were issued on January 13th, 2021. And so the only 16 permits were issued in this rulemaking. And so I believe that it's 40, the remaining 40 permits weren't covered by this rulemaking. And that creates a kind of interesting timing issue because the permits themselves weren't set to expire till next year. So it could be, if this rule stands, that some of the nationwide permits won't be on a different kind of expiration schedule than the other permits that aren't covered by this rule. The other interesting thing is when the court issued it, they gave it a 60-day effective date. And so they're not effective till March 15th, 2021. And so there's obviously been speculation about why they did that. But a lot of people are thinking it's so that the Biden administration had time to kind of review them before they went into effect. And just to review generally, nationwide permits are permits for both structures under the Rivers and Harbors Act, Section 10, and then dredge and fill permits under the Clean Water Act, Section 404. So both of those types of permits can be covered by a nationwide permit. For our purposes, there's 3 of note. So there's the modified nationwide permit 48 for shellfish, and then new nationwide permits for seaweed and finfish. And we've covered this before in some of our other outreach, but the nationwide permit 48 was subject to litigation in the state of Washington. And then the recent executive order on promoting seafood by the Trump administration, stated to kind of think about issuing nationwide permits for both seaweed and finfish. One note that applies to them all is that they've decided to change the terminology from aquaculture to mariculture. And they state in the nationwide permit 48 documents that they did that because they wanted to specify that they're only authorizing operations in coastal waters, and that mariculture occurs in marine and estuary open water environments, but aquaculture themselves can occur in a much broader area, including on land. So that is why there are now mariculture permits instead of aquaculture permits. Okay, so the new modified nationwide permit 48 has one big change that has gotten a lot of attention and which received a great deal of comments during the rulemaking process. And so the 2017 permit limited the area of impacted submerged aquatic vegetation and project areas had not been used for commercial shellfish aquaculture activities in the past 100 years to a ½ acre. And in the new permit that was just issued in January, they've taken away that limitation. And instead, they're now only requiring a pre-construction notification known as a PCN for new and existing commercial shellfish activities that will occur and that will directly impact greater than ½ acre of submerged aquatic vegetation. And next, and the other major change that isn't actually in the permit itself is related to that lawsuit that came out of Washington State. So in Coalition to Protect Puget Sound Habitat versus U.S. Army Corps of Engineers, the U.S. Western District Court found that the agency's conclusion that nationwide permit 48 would have a minimal environmental impact was not supported by the evidence and was arbitrary and capricious. And it was also not in accordance with the NEPA or the Clean Water Act. And as a response to that litigation, the court said that they needed to vacate the permits in Washington State. So they were, no longer in effect. In response to this, the Corps updated their decision document, which is a bigger document where they kind of outline all the evidence and their reasoning for what's in the actual rule itself. So this discussion isn't in the rule, it's in this separate document. And the Corps says that they think this further discussion of the impacts on submerged aquatic vegetation, benthic communities, birds, fish, and other species is enough to satisfy what the court was upset with in that Washington case. And it says in the rule itself that the permit would authorize only those commercial shellfish mariculture activities that have no more than minimal individual and cumulative adverse environmental effects. To complicate this even more, so this lawsuit that actually vacated those Washington 2017 permits is still ongoing, to the point that there was oral argument on this case just yesterday in the Ninth Circuit. And so the purpose of that case is they're arguing, the defendants are arguing that they want the almost 900 vacating Washington permits to be reinstated. And their argument for this is that the 2021 permit hasn't mooted the case. And their position on that is for a couple of different reasons, but for one, they're arguing that it's not even in effect till March. It's currently under review under the Congressional Review Act. And they don't expire for another year if they were to be reinstated and the 2021 rule was not to take an effect. And so they're still kind of procedurally arguing to get those 2017 permits back in effect in case these 2021 permits don't go into effect. Okay, and so then I just wanted to talk briefly about the two new mariculture permits that are in the rulemaking. So the first is for seaweed. And so the rule is specific to say it's only authorizing structures, not operational aspects of seaweed mariculture itself. All operations are going to require a PCN, and that PCN is going to need kind of the map with the location of where the operation is going to be and its dimensions, the specific species that are going to be grown, and then the general water depths for the area. It provides for multi-trophic mariculture. So instead of writing a separate nationwide permit just covering multi-trophic, they included in the seaweed permit the ability to kind of combine it with shellfish aquaculture under the same permit. The permit specifically says it's not authorizing activities under Section 404 of the Clean Water Act, and that they're allowing cultivation, they're not allowing cultivation on non-indigenous species unless that species has been previously grown in that water body. And then it also has a requirement that To the extent practicable, the permittees have to remove any authorized seaweed or multi-trophic structures from navigable waters once no longer in use. And then finally, for the Finfish nationwide permit, again, it's similar, very similar to how the seaweed was written. It's only authorizing structures and not operational aspects. The Finfish one actually got quite a deal of public comments. And so in the rule, kind of explaining their reasoning in the rule, they say that, you know, they want to distinguish between installing a Finfish aquaculture structure and regulating these activities by the EPA, FDA, et cetera. So they're kind of separating those two activities of putting the structure in and then actually growing the Finfish. Again, it's going to require a PCN of the same details that the seaweed does. So location and dimensions, species, and water depths. It is also providing for multi-trophic mariculture, so you can grow shellfish, seaweed, et cetera, along with the Finfish. It also is barring non-indigenous species unless it's previously been grown in that water body. And again, they're requiring the permittees to remove authorized Finfish structures from navigable waters when it's no longer in use. And the nationwide permits actually have not been the subject of a new lawsuit. So nothing at this time has been filed, and they haven't been specifically been mentioned in any of the executive orders. But in the oral argument yesterday, the one attorney was saying that they could probably be fit into some of the general language in some of those permits, but nothing specific at this time. And that could be, again, because they're not going into effect until March. So the administration has a little bit longer time. So do litigation to be filed.
Thanks, Kathy.
All right, and now I'll be talking about the take reduction plan that was proposed for Atlantic right whales by NOAA. This was proposed, it was proposed technically on December 30th, but it was published on December 31st in the Federal Register, very much snuck in there at the very end of 2020. And this is a saga that's been going on for quite some time. Most people on the webinar are probably familiar with the plight of the Atlantic right whale, but in case anyone isn't, just very briefly, the right whale is critically endangered. It was nearly hunted to extinction, numbered less than 100 as recently as 100 years ago. The numbers came back, but there's only about 360 in the wild right now. They are sufficiently rare that when a new one is spotted, whether it's because they're born or just it's a new sighting, it makes the news. A new right whale makes the news. And so that's why this new take reduction plan was such a big deal. There had been a string of cases in 2020 that found that the US lobster fishery in particular, as well as some other fisheries, notably here on the slide, you see the Jonah crab fishery is also going to be affected. These cases, these court decisions found that the fisheries themselves, as well as the federal agency permitting schemes for them, violated the Endangered Species Act. And so after a series of cases, the most recent one, the biggest one, was Center for Biological Diversity v. Ross. That kicked the rulemaking back to NOAA, and that's how this new take reduction plan got developed. It was created by a 61-member Atlantic large whale take reduction team, which includes scientists and industry representatives. And in terms of the actual substance of this proposal itself, it would require gear modifications to reduce the number of vertical lines. So specifically how that would work, as you can see in the illustration that is the background for this slide, that demonstrates what it looks like when a whale gets tangled up in one of these lobster or crab pot fishing lines. You have the buoy on the top floating on the water, then the ropes falling down connected to all of these traps. Specifically, the gear modifications that would reduce the number of vertical lines is they would want more traps on the lines themselves. That would hopefully reduce the number of lines out there. And it would also require introducing gear modifications, specifically either weaker ropes entirely or the insertion of weaker strands into these larger ropes. And so additionally, there's also existing seasonal restrictions that are going to be modified, as well as new seasonal buoy line closures. This all comes together with the last point that you see on this slide, which is that this new rule would allow lobster fishermen and crab fishermen to experiment with ropeless or buoyless alternatives. The hope is that the entire fishery moves towards that technology, or the technology catches up with the need. And at least per NOAA's stance right now, the feeling is that ropeless or buoyless alternatives for lobster and crab fishing in the Northeast would allow the fisheries to coexist with the right whales, that they wouldn't need these seasonal closures in order to get those lines out of the water. So, and the very last point here is that it would require modified gear marking, specifically to differentiate between the states of the Northeast. That was something that wasn't as clear cut before. And just to emphasize, this is a proposed rule, not a final rule yet. So it's currently being frozen while the Biden administration reviews it. And we also haven't seen any court action yet, because generally any court action would arise after the rule has been finalized. So that's something for us to keep an eye on moving forward.
Great, thanks. Yeah, so if that wasn't enough, we just wanted to give a heads up to other rulemakings to watch. These are ones that happened much earlier in 2020, so they're outside of that kind of midnight regulation type window, but that we expect to see changes, and that might be of interest to Sea Grant programs. The first one is the updated NEPA implementing regulations. These are issued by the Council for Environmental Quality, which within the White House. The final rule was issued in July. This has been controversial. Multiple lawsuits have been filed to challenge the regulations. This has been specifically flagged by the Biden administration for review. The incoming chair of CEQ, director of CEQ, is a well-known environmental law professor from the University of Arizona. So I expect there will be action related to the NEPA implementing regulations in the coming year. The other one is the ongoing, never-ending saga, Water of the United States rule. That was issued in April 22. Lawsuits abound in this one. Oh my goodness, we have so many lawsuits. We've got lawsuits for the original, like one that the Obama administration issued, ones on the Trump administration. There'll be lawsuits about this one. It's a big mess. But the Biden administration is filing motions in court to ask the courts to send it back to the agencies or pause the litigation to give them a chance to review and rewrite. So stay tuned for WOTUS. Yeah, so somebody had a question. Do you see these pre-July 2020 regulations being changed or deleted during settlement discussions? It's possible, depending on how these court rulings go, what the parties negotiate, what the new Biden administration DOJ does in their motions. So yeah, I think we'll just have to stay tuned to the dockets to see how these cases are progressing. And then just with the time that we have remaining, even though this was really focused on regulations and just checking in on those like major ones that we thought had the most relevant for Sea Grant programs, there's a lot of other agency actions that were happening at the end of the Trump administration that were below the level of rulemaking, but that could be really important for setting policy and may also, again, be reversed, modified, changed by the Biden administration. So, and some aren't that controversial. So, you know, these are just kind of FYIs. So under the Environmental Protection Agency, in December, the EPA approved Florida's request to be able to implement the Section 404 program. So normally the Corps of Engineers, or traditionally the Corps of Engineers, has implemented Section 404. Florida was the first state in 25 years to apply and receive approval for this. Only 2 other states have authority to implement Section 404. That's Michigan and New Jersey. This is different than Section 402, the NEPIDs, the non-point source discharge elimination system permits. Most states have applied and received approval to implement Section 402, but this is the Corps of Engineer program. So this is the one Kathy was talking about with respect to the nationwide permits. And so this is interesting that Florida sought it. It has been controversial. You know, there's just some philosophical differences about whether states should run these programs versus the federal government. That's just kind of been there since the beginning of the Clean Water Act, but something to stay tuned for. Also, there was guidance issued, follow up from the Maui County wastewater case. And Tara, I guess I'll turn it back over to you to chat about that.
Yeah, so basically the Clean Water Act, as you'll know probably, prohibits discharges of pollutants from a point source into navigable waters without a national pollutant discharge elimination system permit. And so the Supreme Court said that pollutants that go from a point source and travel through groundwater before reaching waters of the United States do need a permit. So this was just a memorandum that gave some guidance on that case, and it just places the functional equivalent analysis that the court went into context when implementing the program.
Thanks, Tara. So next up are some NOAA actions, and we'll turn it over to Olivia.
Thanks. So NOAA with the Fish and Wildlife Service issued a proposed authorization for seismic surveying that might incidentally harass polar bears in the Arctic National Wildlife Refuge. So for this project, a corporation submitted a request back in August for a project for 3-dimensional seismic surveying in the Marsh Creek area of the refuge, where there are known polar bears. Under the Marine Mammal Protection Act, the Secretary may approve actions that incidentally harass marine mammals. So this was a proposed incidental harassment authorization, and the public comment period closed on January 7th, and the agency has not yet published a final authorization. So this means that the project is not going to move forward until there has been a final harassment authorization and also an approved final environmental assessment for the project. Thanks. Next slide. So then with the Department of Interior, the solicitor issued an opinion for how the agency is going to interpret interference with reasonable uses for offshore wind development. Under the Outer Continental Shelf Lands Act, when the agency is approving offshore wind energy development, the project is not going to be approved if it interferes with reasonable uses of the exclusive economic zone. One of the major uses is commercial fishing. So the opinion was attempting to clarify how much interference should be allowed. Is it minimal interference, no interference at all? Kind of finding that balance there. So the solicitor's opinion said the agency is going to err on the side of less interference and will prevent any unreasonable interference, but it's not going to reject a project if there is minimal interference or reasonable interference.
Thanks, Olivia. And so under moving to the U.S. Department of Agriculture, so in January, right here at the end, 1 week before the inauguration, the USDA and FDA announced a new MOU on animal biotechnology. This is likely to be controversial. The poultry industry especially has been arguing and lobbying for quite some time that the USDA should have regulatory responsibility for animals made or developed using genetic engineering if it's for agricultural purposes, including food. Up until this point, the FDA has asserted jurisdiction over those type of animals. If anyone's familiar with the Aqua Bounty super salmon saga, the approvals for the use and sale of Aqua Bounty salmon for food was handled by the FDA. And so the FDA has been reluctant in the past to give up that authority. But it appears a deal was reached between the FDA and the USDA, and they are now shifting that responsibility to the USDA. The FDA will retain some authority for a few genetically modified or genetically engineered animals if it's used for like certain pharmaceutical or different purposes, but it's a much narrower approach. The other thing that we've gotten some questions about recently is the halt to the coronavirus food assistance payments that the Department of Agriculture has. This is just something that got caught up in the regulatory freeze that, you know, wasn't necessarily controversial. The USDA had put out a rule announcing kind of new eligible commodities, updating payment calculations, reopening the application. This was kind of due to the next round, right, of funding. And it was within the window for when the regulatory freeze is. So producers may continue to submit applications during the review period, but we'll just kind of have to wait and see what happens at the end of the review period with that particular rule. It's likely to continue to start up again, right? Because Congress has appropriated the funds for those commodities and that relief program. Woo! So can't believe we were able to do that in an hour. I don't know, we might have overwhelmed anybody, but if you have questions, please feel free to put them in the chat box. Also, stay tuned for our next installment of our webinar series. Coming up next are executive orders. And so I would encourage you to join us on March 3rd, same time, 1 p.m. Central, as we work our way through the flurry of executive actions that have been issued by President Biden, some of which expressly revoke executive actions by the Trump administration. Some have pertained to some things that are interest to Sea Grant. And we look forward to continuing to share that information. And as always, I encourage you to reach out to any of the members of the National Sea Grant Law Center staff if you have questions about things that we've covered in the webinars, or if you have legal questions coming up in your work that you would like some help navigating. So we'll give it a little bit extra for comments to come through the chat. And thanks again for joining us. We really appreciate your participation.